Hey guys, Shelby Mathis here, and today we're going to go over 3 things that you should not be putting into your living trust. Now, rather than have me go over it, I actually have a colleague, Amanda Wynalda, who's a frequent contributor to my channel, and she's going to be explaining these things that you may not want to put into your trust or you should not put into your living trust. So I'm going to hand it off to Amanda. Take it away.
Hey, so there's a lot of videos out there talking about funding your living trust, but no one really talks about what types of assets you shouldn't put into your living trust. I'm Amanda Wynalda, an attorney with Anderson Advisors, and in this video, I'm going to break that down for you. All right, so let's get started. So when it comes to funding your living trust, we have this preconceived notion that we have to put all of our assets into our trust so they can bypass probate. However, there are some specific assets you definitely don't want to try to place in your living trust because they can cause negative tax ramifications, or worse yet, they could bring you liability. So number one is going to be vehicles. Vehicles. This is going to include cars, boats, motorcycles, RVs, and even equipment like tractors and trailers. The fact of the matter is that anything that's a title asset like a vehicle, there's just no point in putting it into a living trust because it's very simple to transfer those assets to a beneficiary when you pass away. Typically, all you're going to need is a copy of a death certificate and in order to transfer that item to another individual. So maybe you want your vehicle, maybe your truck or a vintage motorcycle, for instance, to go to a specific person, your son or daughter, when you pass away. Just write that down there in your personal property memorandum or your final instructions listed with your living trust. Your successor trustee will then see that. They'll contact the DMV, they'll get a copy of your death certificate, they'll likely complete a simple form or affidavit, and then transfer that asset or that vehicle over to the beneficiary of your choosing. It's that simple. So that's the main reason why we're not putting vehicles in the trust, because you just don't need to in order to transfer them without having to go through probate. Now, the second reason why I wasn't put my vehicles into a living trust is because of lawsuits, asset protection. You see, when you retitle your vehicle into the name of your living trust, you're just exposing that fact that you have a trust to a potential creditor. So let's assume there's a car accident and the vehicle is titled in the trust name. I can guarantee you that plaintiff's attorney, they're going to know that if you're at fault or the person driving your car is the one at fault, they're going to name your trust as a defendant in a potential lawsuit because it's on title. So if you want to keep your trust out of lawsuits that are related to vehicle type accidents or boating accidents or RV accidents, then you don't want to put those types of things into your living trust. Keep them in your own name. Now, the third reason you don't want to put vehicles into a living trust has to do with insurance. And it just comes down to the fact that insurance companies, they seem to just get really confused when it comes to figuring out how to insure a vehicle that's in a trust name. So I tend to avoid placing those vehicles in any sort of trust because people just can't figure it out. I don't know why, but just certain insurance companies, they go, hey, you have to go around and you have to shop for an insurer, and you want to definitely put that into a trust, and you're looking for anonymity because you've had problems with people in the past, then sure, you can do it, but you are going to have to do some more legwork. And I get it. That's going to make sense for some people, but just keep in mind if you're doing that insurance can be problematic when you're putting a vehicle into a trust. Okay, now the second asset you shouldn't put into your living trust is annuities. So this includes accounts like 401ks and IRAs, retirement accounts, right? So these type of accounts need to stay outside of your living trust. Interestingly, these accounts are actually trust agreements themselves, where a custodian is technically managing the assets for you, much like a trustee would. Now, why do we want to put these types of accounts in your living trust, or why don't we? Well, first of all, you may inadvertently be creating a taxable event for yourself, basically a liquidation of that asset. And then all of a sudden, you'll have these immediate tax consequences, or even worse, you may invalidate the special nature of that particular investment that you're holding, making you subject to income tax and even penalties. So instead, we're going to rely on the beneficiary designation on these types of accounts. What that means is that these accounts allow you to name a person that will receive the funds when you pass away. And those assets are automatically paid out, no court intervention or oversight needed. So if you're married, you'll want to list your spouse first so they can receive the funds, or at least control of the accounts outright, and use them to take care of the family in your absence. You've likely gotten this part right. Most people do. The bigger mistake people make is listing their children directly on these accounts. even as a contingent beneficiary. I mean, think of the scenario where you and your spouse both pass away in a tragic car accident, for example, and your children are the contingent or next in line beneficiaries listed on these types of accounts. Well, they end up getting those funds immediately. Now, if your kids are young, we may not want that, right? And if you don't have a trust, then a court will need to step in and name a person to handle the funds until your children turn 18 and can get them. And we may not want that person. It may not be the person we've chose. But even if they choose someone that you would like, we still may not want our kids getting their hands on a pile of cash at just 18 years old. I know I don't want that for my kids. So what we're going to do is instead name your living trust as the contingent beneficiary, so the one after your spouse. And if you don't have a spouse, then your living trust can be listed as the first beneficiary. No problem there. This way, you, through the trustee that you choose for your trust, can control when your kids receive the funds so they aren't wasted. The trustee can even continue to invest and manage the accounts responsibly so that your heirs have a nice little nest egg waiting for them when they're mature enough to know what to do with it. The provisions or terms of when your kids get the funds or for what purpose, like if they can get a chunk of cash to pay for college or to go to trade school, all of those provisions need to be detailed in your living trust. So it's going to be super important to get that set up first. Now, the final asset I would keep outside of my living trust is my life insurance. Our life insurance. Life insurance is an example of a POD or pay on death account. This means you can name a beneficiary and the funds go directly to that person outside of probate. Just like with your retirement accounts and vehicles, if you can bypass probate, then there's no need to put life insurance into the trust. What you'll do instead is name your spouse, just like you did with your 401k, as your primary beneficiary, if you're married, of course, and then have your trust name as the contingent beneficiary, so it would receive the life insurance proceeds if your spouse was no longer living. Another thing you might want to consider is an irrevocable life insurance trust. If you have life insurance and it's of a considerable value, or you live in a state that has a very low estate tax, you don't want your estate to pay extra tax on those insurance proceeds. For example, let's say you have an estate over $2 million and you have a $2 million life insurance policy, but the estate tax exemption is only $3 million. Well, your estate will get hit with a tax on that additional $1 million that's in your estate because of the insurance. And that could be up to 20% in some states. But if you put the insurance policy into an irrevocable trust, the proceeds are not included in your estate when you pass away, and you would avoid that additional estate tax on those funds, leaving more for your surviving family members to use during their lifetimes. So these are the main assets you should not put into your living trust: vehicles, retirement accounts, annuities, and life insurance, because these assets pass outside of probate with proper beneficiary designations. Everything else, it's going in, and it's super important that you get your trust fully funded. Otherwise, your loved ones will end up in probate sorting, or even worse, fighting over the assets that were not in the trust. Just make sure you have the proper beneficiary designation so that your estate plan goals are carried out appropriately. If you found this video helpful, be sure to hit the like button. And if you want to stay up to date on the latest tax, asset protection, and estate planning news, hit that subscribe button.